Very good morning to audience. I am going to cover what are the main provisions of Offshore Area Mineral Development and Regulation Act. As this act was amended in year 2023, and this is a comprehensive legislation enacted by the parliament. It primarily aims to regulate, facilitate the development of mineral resources within India's territorial water and continental shelves, exclusive economic zone, and other maritime zones. The Act outlined the provisions for acquiring the operational rights through permits, licenses, leases, and established the procedures for reconnaissance permit, the exploration, and the production. The various rules which are being framed under the Offshore Area Mineral Development and Regulation Act are Offshore Area Mineral Auction Rules, Offshore Area Existence of Mineral Resource Rule, which has already been notified by Government of India in June 2024, Offshore Area Mineral Trust Rule, Offshore Area Operating Rights Rules. Here in offshore area, instead of mineral concession, we are using the word offshore area operating right rules and offshore area mineral conservation and development rule 2024, offshore area prevention of illegal mining, transportation and storage rules, and offshore area of rules for atomic minerals for atomic mineral purposes. The significant aspect of that include establishment of the central administering authority, the creation of safety zone to protect the personal and property, formation of offshore area mineral trust to fund the research and mitigate ecological impact. The Act also detailed the financial obligation of leases, including royalty payment, contribution towards international seabed authorities. Additionally, it provides mechanisms for civil liabilities, enforcement, and adjudication of dispute. The legal framework ensures the responsible and sustainable exploitation of offshore mineral resources while safeguarding the environment and public interest. So these are the main aspects covered in the Act. Some of the new terminology which used in Offshore Area Act are administering authority. It will be equivalent to state government in on land cases. Just like in all leases are granted by state government in onshore, in offshore cases, a central government administering authority shall be responsible for overseeing and implementation of Act. The authority has the power to grant permit licenses, leases for offshore mineral activities. Then offshore area means area in territorial water, 12 nautical miles, and continental shelf zone, exclusive economical zone 200 nautical miles from baselines, and other maritime zone of India beyond even 200 nautical miles, which will be as per the this continental shell exclusive economic zone and other maritime zone Act 1976. Then operating rights, here terms operating right is used instead of mining lease. Operating right means all rights, which is a composite license, which is a permit, reconnaissance permit also, or a exploration license, or a production lease. Here again word prospecting license, instead of prospecting license, term exploration license is used in offshore areas. Then reconnaissance permit, as you already know, it is similar to onshore land. Composite license, it will be a exploration license come production lease, which is in two stage. Operating right grant for undertaking first exploration, then it will be converted into the production lease. Then exploration license means the exploration granted for the purpose of undertaking exploration. And the standard block. Here the word standard block is used. Standard block cell 1 minute by 1 meter will be a standard block for granting the this mineral rights. Then recognition and exploration and production operation under permit license, as in the section 5 of onshore, it is similar to that. All this, every exploration license, every recurrence permit or production must be under a license, under a permit. So this is the provision is similar to that of onshore land. Nothing is new in this section. Then grant of operating right eligibility. As we already know, for grant of operating rights in offshore area, one, a person has to be an Indian national or a company established under Indian Company Act, or only operating rights means operating lease can be granted unless the existence of mineral resource in offshore area has been adequately established as per offshore area mineral evidence of resources rule 2004. It is similar to section 5 2b of onshore land, in which there are two conditions. One, existence of mineral is established, and the approval of mining plan is there. Here, though Act doesn't mention any condition for approval of a mining plan, but existence of minerals needs to be there. Then termination of operating rights as per section 7. uh, if right holders, if holder of a permit or holder of a licensee or exploration license failed to commence the operation, recurrence operation within a 6 month of grant execution of recurrence permit, or within 1 year from composite license, or within 1 year of exploration license, or production lease within a 2 years, or it is the similar case as in the onshore, where if production is discontinued for more than 2 years period, then leases will be terminated by the central government. Then reservation of areas, the central government under section 8, the central government may from time to by notification reserve the central area for any government undertakings, for PSU, for state or joint venture, which in which government of is having 74% capital share percentage, then they can reserve the area. Recently, a construction sand block has been reserved for Jawaharlal Nehru Port Trust towards the Gujarat, Andaman, and Maharashtra coast. Then power to close area. The central government in the public interest by order in writing to permittee, licensee or leasee close any area. This is equivalent to determination of mining lease for consideration in the public interest, for natural environment, protection of pollution, or to avoid danger to public health, community, communications. Communication means communication lines, and ensure safety of the offshore structure or platform. So if there is a public interest is involved and there is a threat to this, then central government can determine the area. This is a power given under section 9 to close that area. Then composite license. As I already explained you, the administering authority here, instead of state government, with prior approval of the central government, may in respect of any area where existence of mineral resource has not been adequately stabilized, where mineral resources have not been adequately stabilized, in such cases a composite license will be given, which is having a two-stage. First you go for exploration for 3 years, and after doing a satisfactory exploration you can apply for a mining lease. operating lease, not mining lease. Here, word operating lease is used. The area granted under the composite license shall comprise continuous standard block. As I told, standard block, which and this all together, all continuous stick block, the single block should not be 30 minutes by 30 minutes. And the licensee, composite licensee, has to complete the exploration operation satisfactorily within a period of 3 years from date of grant of composite license. And if due to any practical reasons or any exigencies he is not able to complete the exploration work, he can apply for extension for further 2 years period. So there will be a 5 years period total for the exploration license granted under composite for completing exploration. And on completion of exploration satisfactory, the operating lease shall be granted for 50 years period within a block of 15 into 15. So here operating lease means mining lease will be 50 minutes by 50 minutes block, whereas composite license can be granted up to 30 minutes by 30 minutes coordinate areas. Then grant of production lease as condition under section 6, where administrative authority consider that where existence of mineral has been already proved, established as per mineral evidence resources rule, then they can grant the direct production lease through auction mode only. It is very clear all composite license and production leases will be granted through auction only, and the period of auction production lease will be 50 years. It will be granted for 50 years. And it is also necessary that the area which is being granted under production lease should be a continuous standard block, and an area and maximum area will be by 15 minutes into 15 minutes only. So this is the case of a grant of production lease. Then area limitation for licenses and leases are there, as I already told that for PL, no person shall acquire in respect of any mineral, group of associate mineral, any prescribed one or more exploration license, composite license or product, all taken together covering a total area of 45 into 45. So this will be a 45 into 45 will be the maximum area for grant of this. No person can be granted more than 45 minutes 45 stern blocks in the license or leases. Period of commencement of operating rights. Once the recurrence permit is granted, the party has to commence the operation within 6 month period. For composite miners license, the period is for 1 year, and for exploration license, period is for 1 year, and for production lease, period is for 2 years. So in this prescribed period, one has to start or commence his operations. Otherwise, area will be terminated. Then offshore area mineral trust. It is similar to district mineral foundation trust. A provision under section 16A has been made which manage the fund accrued from the offshore area mineral activity. This sections details about the how the composition will be there, how what will the function and administration trust ensuring transparency accountability. A separate offshore area mineral trust is under preparation and will be notified shortly. Similarly, other financial obligations are also detailed in the Act. The financial obligation of leasing, including how the royalty payment is to be paid, how the contribution to offshore area mineral trust to be carried out, and detailed funding mechanism for research and ecological mitigations measures. Then if area section 18 of the act is very important, This is related to contribution to International Seabed Authority. If the offshore area which is granted is beyond 200 nautical miles, means it is beyond 200 nautical miles, then UN section will be applicable, and for this International Seabed Authority will a contribution prescribed by International Seabed Authority is to be paid by such operating leaseholders. So then section 90 is about safety of person and property, as this is a general conditions where every permittee, licensee or leaseholder undertaking recognized permit or exploration operation or production lease under section has the responsibility for ensuring a concerned person's safety and health of the person working or driver or safety and security of property engaged in the operation. So this is about the safety of the person and property. Then prevention and control of pollution and protection of environment. This is also very important. The emphasis or importance of environment protection in offshore mining activities. This because being a very sensitive area, it mandate measures for pollution controls, marine environment protection, and systematic development of mineral to prevent the ecological degradation of the area. Then similarly, Stephanie and Bice, these are the central governments and Indian authority is empowered to issue the directions for any mining related activity for safety, for environment protections in generals. And power of entry of inspection and seizure that has been granted under section 22 for any official authorized by central government. And transfer of leases and licenses, composite license can be done prescribed as per the terms and conditions set out in the operating right rules. Then civil liberty and enforcement. Under this right mechanism for civil liability and enforcement of the act, provision for penalties, appeals, dispute resolutions, and ensure compliance and redresses grievance. So these are the general terms and conditions where every act is having. And the next is then penalty. Here, any violation of the act which is for which a penalty may extend to 5 years or fine of 5 lakh rupees, which may extend to 10 lakhs with or both. So this is the penalty provision under this. So I have covered in nutshell the various provisions of Offshore Area Mineral Development and Regulation Act. Thank you very much for joining this session.